Hi, I'm Jacob. I'm one of our senior associates here at Genuine Legal, and today I'll be answering some questions about family law matters that have been written by you. One of our questions is, when a child is living and is settled overseas, to obtain a passport in another country, you'll need to consider the laws and rules of the country that the child is living in. So oftentimes an Australian family lawyer can't assist you to understand what those rules are, and you should consider contacting a family lawyer of that particular state or country to understand what and how you might go about applying for a renewal of a passport. Now, if a child is in Australia, then I can certainly be of assistance. Oftentimes, parties do require the consent of both parties to obtain a passport. There are some minimal exceptions, particularly concerning families involving serious cases of family and domestic violence. You shouldn't be afraid to contact the passport office to learn more about some of the rules in this space, but it is possible for parties to apply to court to obtain the leave of the court to apply solely for a passport for a child, perhaps if the other party is uncontactable or unwilling to provide their consent for reasonable travel. The court's a major proponent of connecting children with extended family, so if you have extended family overseas and wish to take your child to visit, certainly consider making an application or at least seeking some advice. Resolving parenting disputes when one party is incarcerated can be difficult, but the court is familiar with these challenges. If your ex-partner is incarcerated in Australia, it's important that you know that you do still need to obtain their consent if there are no court orders in place allowing otherwise before you can, say, obtain a passport for your child to travel overseas, even if it is the case that the children haven't seen that parent for some time. First step would be to consider instructing a lawyer to write to your former partner. The service of that letter can take place through the corrections system. Family lawyers are familiar with this process. And if there can't be an agreement reached with your former partner who is incarcerated, a court application can be commenced to seek the sort of relief that you're looking for specifically for your child to travel overseas, or for other orders to be made for the benefit of your child. It is the case that if there is a court event, the family court has a process by which they ensure that prisoners, those incarcerated, are afforded due process, can participate in the events and receive legal advice if required. So certainly with the right sort of support and preparation, there should be no practical delay for you proceeding through family court to obtain your sought after orders. We're sorry to hear that your ex is making threats to commence litigation against you. Prospect of going to court can be quite daunting, particularly if you've not been to family court before. It's important that you seek legal advice at this stage, because depending on some of the other circumstances in your matter, a mediation may or may not be appropriate. For most matters, particularly those without urgent circumstances, a mediation needs to have occurred within 12 months of either party making an application to the court to seek relief, that is to say, parenting orders concerning your children. And certainly at that mediation event, you are under no obligation to agree to a proposal put to you by the other party. It's important that you consider what is best for your child or children before assenting to any particular proposal that's put to you by another party. The court is there to assist, and family lawyers are plenty experienced in helping those even with difficult ex-partners who might be making threats of litigation or perhaps are better financed than yourself to ensure that at a competitive price you can obtain orders that are in your children's best interests with a more informed understanding of what a court might do with your matter. It's critical that any consent is reached on the understanding of what a court may or may not do with your children's case, because remember, any consent ordered provisions must be put through the process of being effectively double checked by the court through an application for consent orders before made binding. The last thing we want is for an agreement to be reached at mediation and then for a court to reject it. And so for advice about how you can get your parenting arrangement right the first time, be sure to reach out to the folks here at Genuine Legal.